BITBOY predicts that Ripple XRP will hit $10,000. At this time, the Securities and Exchange Commission (SEC) was recently encouraged by U.S. Representative Brad Sherman to pursue cryptocurrency exchanges that accepted Ripple's XRP asset. Welcome to XRP Insider. We provide the latest news of XRP Ripple. To stay updated with exciting news, please do like, share, and subscribe to our channel. To know more, please watch till the end. Sherman, however, recently made another accusation against the token during a conversation with Fox Business reporter Eleanor Tourette. The CEO of Ripple, Brad Garlinghouse, recently tweeted his displeasure at the rise in fraudulent bot activity on the well-known site. He also finds it unbelievable that he still needs to contact Twitter's help service to report his copycats. He also mentioned how many confirmed bogus accounts there are on Twitter. These bogus accounts go by the names of Gary House, Vitalik Buterin, Changpeng Zhao, CEO of Binance, and co-founder of Ethereum. The CEO of Ripple is still waiting for action, and a ton of fake accounts are exploiting the site to tweet about cryptocurrencies. He also posted the email from Twitter that he had received. A registered account is mentioned as not indicating a breach of their identification policy. Some crypt analysts and specialists have noticed these bogus cryptocurrency accounts, and Twitter bot responses in these accounts pretended to be Nance CEOs and posted spam on Twitter. False XRP tokens being distributed on Twitter using the name and image of wild garlinghouses. The social media company is involved in a lawsuit against Elon Musk over the denial of a $44 billion takeover agreement, alleging that the Twitter bot data it provided was false. Musk is the richest man in the world, and the lawsuit stems from the rejection of the offer. It states that there are a great deal more phony accounts active on the site than the business anticipates. For breaking securities rules, the U.S. Securities and Exchange Commission (SEC) has brought multiple lawsuits against various businesses and people. Additionally, Gary Gensler, the chairman of the SEC, made a number of statements regarding the regulation of cryptocurrencies in light of the fact that Gensler has been accused by lawyer John Deaton of interpreting the Securities Act broadly. The chairman of the CFTC suggested in an interview with CNBC that they should regulate some cryptocurrency-related assets alongside the SEC. Becky Quick also noted that the Securities and Exchange Commission has established some precedents and provided numerous instances of people settling disputes with the agency. She continued by saying that these actions were proof that the SEC needed to exert more supervision over the sector. The SEC chairman responded that everything in the law is clear as a result. He asserts that the majority of tokens are securities given the relevant facts and circumstances. At the same time, he emphasized that when a group of businesspeople collect money from the public and they all anticipate making money off of it, they ought to be transparent about it. This statement, however, alarmed John Deaton, a lawyer who has amicus curiae, a friend of the court status in the XRP dispute. In his opinion, the SEC chairman is mistaken on this. Gensler disregards two fundamental legal requirements. It misses the fundamental criteria for a common company, to start. Second, the SEC chairman disregarded tokens' non-investment usage. It is not a security if it is not purchased for investment. The Securities and Exchange Commission's chairman, he said, is figuratively poisoning the populace with cryptocurrency. The SEC chairman's revised view of Bitcoin regulation and the Kim Kardashian issue was discussed earlier by DTNS's attorney. The American celebrity resolved the legal matter by paying a fine of roughly $126 million. The commission no longer refers to cryptocurrencies as digital securities, the attorney continued. In the Ripple and Library case, this phrase was utilized. Unexpectedly for everyone, the SEC chairman now refers to them as cryptocurrency securities. Over the weekend, requests for summary judgment were publicly filed with the Securities and Exchange Commission. Nevertheless, they weren't anticipated until today, September 19, 2022. Brad Garlinghouse, Chris Larson, and the Breaking of Ripple Labs filed a move for summary judgment asking for judgment as a matter of breaking the FCC. In the Southern District of New York, the petition was submitted separately by the parties. and the SEC based its case on the idea that the cryptocurrency and investment contract made by XRP in a joint venture is a security and therefore be subject to U.S. securities regulations. The SEC further asserted that Ripple convinced many investors to purchase XRP by promising them enormous gains in the future, suggesting that the cryptocurrency is a security. The defendants, on the other hand, Ripple Chris Larsen and Brad Garlinghouse, argued that because there was no agreement, regulators could not demonstrate that buyers of XRP did so with the expectation that the purchase would result in a profit. Additionally, token holders typically profit from the asset due to supply and demand, said Ripple's attorneys. Accordingly, XRP holders are not entitled to receive earnings from Ripple. Additionally, if the business is not making money from XRP, they cannot charge it with any violations. I rippled in. Executives from Ripple and other interested parties have already commented on the petitions submitted. Garlinghouse, CEO of Ripple, asserts that it is clear the SEC is not interested in implementing the law in this situation and that their desire to start over demonstrates an inappropriate attempt to extend their authority well beyond what has been granted to them. By the Congress, the SEC's filings from today demonstrate that they aren't interested in upholding the law. Instead, they want to reinvent it all in an illegal endeavor to extend their authority well beyond that which Congress has granted them. Ripple General Counsel Stuart Alder also provided commentary on the situation, stating that despite 2 years of litigation, the SEC has not yet discovered any investment contracts. The Supreme Court's Howey test cannot be met by the SEC in any way. All other information is noise. Irati only added. Finally, the day has here. You can see a copy of our motion for summary judgment here. The Securities and Exchange Commission is now in serious difficulty, according to attorney Jeremy Hogan, a partner at the legal firm Hogan, following the filing of a recent request for summary judgment. And after reading the summary, I discovered that the SEC has a few significant issues. One of her experts concurs that market forces, not Ripple, are mostly responsible for price movements in XRP. The Securities and Exchange Commission has the onus of proving everything in this case, thus the fact that it has not noted that any of the XRP buyers had heard Ripple's purported marketing spiel is a major issue. I just read the papers, and the SEC has a few significant issues. I'll see the video tomorrow. 1. All of its experts concur that market forces, not Ripple, are primarily responsible for variations in the price of XRP. Ouch. Concessions of this nature are ideal for summary judgment. Upcoming court dates. The summary of objections are anticipated to come by October 18th, and Ripple has over a month to object to this group of petitions. By November 15th, when all briefings will have been finished and the court will be awaiting the tourist's ultimate judgment, it is anticipated that the answers to these questions will be received. According to James K. Feeling, earlier Judge Torres will rule on the expert petitions in the decision and summary procedures and the current price of XRP on March 31, 2023. You can see yourself on the screens for today, and the total trading volume for the past 24 hours is $1,294,436,065. Our